All right, once again, thank you very much, colleagues. Please do keep your microphones off and your cameras off. Then welcome again, once again, Professor Bruce, and thank you so, so much for dedicating your time to teach us in this, I don't know what to say, this important subject of the law, which I know nothing about. But thank you for availing yourself and giving your time to our members of PAVASA. Over to you.
Thank you very much. Just to correct one thing, I do not presume to be in a capacity to teach advocates, but hopefully I can arouse a bit of enthusiasm on issues that have to do with environmentalism. Should I keep my video on or off?
Well, it's up to you. It's up to you. Yeah.
No, that's fine.
All right. Thank you.
Thank you very much again for that very warm and pleasant introduction. I should say that when I got the invitation, I was really honored and I accepted it without even a second's thought. So the paper that I'm presenting on today has already been published. It's been published in the Potchefstroom Electronic Law Journal. If you are interested to go and read about it, you can find it online. What I've tried to do now is to truncate it in such a manner as to make it amenable to a presentation of this kind, which would be for a short space. All right. So to start off with, as you might have heard in the introduction, I'm a movie enthusiast, and I think The Matrix is one of the best movies ever made to date, at least the first three ones of them. This picture that you see here is of the Merovingian, and he is a guy who had a huge sophistry in wine, and he had a very love affair with language. Now, what I want you to remember as I go through this presentation is his statement here, but mostly the last part where he speaks about causality, action, reaction, cause, and effect. So let's start with stuff that we're all familiar with. You would recognize this picture as the Cape Town almost day zero. It never came to be, was a threat. This is representative of the Jagersfontein tailings dam collapse, destroyed a bit of property and surrounding environments. These would have been the Durban floods, which have been happening over the last few years. A lot of people have died from this, and a lot of property has been destroyed as well. This represents the Philippi horticulture case that had to do with an environmental authorization. And this has to do with the deadly air case, which I will speak to a little bit during the presentation. So again, going back to the Merovingian cause and effect, there is nothing that comes without a price. All the actions, all the tragedies that I've just shown right now were either as a result of actions that were taken or actions that were not taken on a governance level. Right. So when I started working on this paper, I was working with experimental thoughts. That's when I just got the Alexander von Humboldt, had a chance to go to Germany. And so I had to come up with a topic and some ideas which were innovative at the time. And I thought this one was. Because of that, I had to work with a lot of generalities rather than specificities. And I had to tackle and address certain stubborn realities which the country is facing, two of which, as you can see from this picture, it has to do with load shedding, and the other one has to do with poverty, which is rife in the country and for which the state has to deal with. If you, or if any of you has watched the Avengers trilogy, you would recognize this individual. This would be Thanos. Thanos is representative of a crisis, or if we are to use his own words, he is destiny and he is inevitable. The storyline, as I would like to put it now, is that we are in a time of crisis. Now, you can call it a governance crisis, you could call it a climate crisis, a political crisis, it doesn't matter. The point is we are in a time of crisis. And because of that, I wish to make two certain points. The first one being that governance is non-neutral, and that certainly has consequences for how we must overly view governance. And the second one, that there is a disconnect between promise and delivery. What I did in this paper was to diagnose rather than to give comments and recommendations. And my diagnosis for this disjuncture is that the country is suffering from what I term hollow environmentalism. Now, how did I get there? in getting to this idea of whole environmentalism, I started with the law. Obviously, the law is the starting point if we are to maintain ecosystem functionality. Without ecosystem functionality, then we realize that our waters, our land, our air would be in trouble. It could even be unsafe for us. So legal and policy frameworks are the centerpiece for governance in general. However, though they may be the starting point, governance is tricky, not least because it's men that have to make decisions. So we know for a fact that men come with their own idiosyncrasies, they come with their own ideologies, and many times if they are affiliated with a certain political party, then they would have policy standpoints which end up being part of government policy or government laws. So that's one complication. The second one is that the state has a monopoly on the governance itself and also on violence. One might ask and say, well, don't corporations also have power? Yeah, sure, corporations have power. You've got big ones that even have budgets bigger than some African countries' GDPs. But you realize that their license to operate is given by the state. And the state has monopoly over violence because only the state can sanction penalties, for example. Now, because of this power that they have, those who are in government, that is, they have the capacity to create this schism in society. Consider the statement by the minister down here. It says, many think that there will be no coal generation by 2030. I can assure you that there will be a lot of coal generation by 2030. It's kind of statements like this that create the schism between those that would have coal remain in the ground and those that believe that coal should be exploited for the benefit of its citizens. Now, I understand the context within which the minister was speaking, but the schism still exists because of his statements. There's even more then. Our laws have an aspirational tone. They convey ideas like, okay, what is the ideal world? The ideal world we would love to have. And this is further complicated by the fact that we've got open-ended laws, which are for the most part implemented through wide levels of discretion. If you know anything about administrative law, you would know what I'm talking of. An example would be the use of sustainable development or sustainability, which to this day remains a policy choice. I'll put a case down here, the West Coast rock lobster case. This was a very fascinating yet tragic, if not funny case. The authority that has to do with West Coast rock lobsters, they work with science. In science, there's a term called the total allowable catch. Now, this total allowable catch represents the number within which, if you exceed it, you can reach a tipping point. It becomes dangerous to continue harvesting the West Coast rock lobster. So overall, when they publish the numbers that have to be fished or at least harvested within a year, they have to be within the total allowable catch. The administrator, for one reason or the other, decided to exceed these numbers. And one of the arguments was that we're doing it for sustainable development and to uplift the community. For good reason, the court obviously reversed this decision because it was clearly irrational. It brings us then now to a stubborn reality, that reality being that governance is non-neutral. It's non-neutral because those in governance act with specific intent, and the laws themselves are kind of contradictory in a sense. What you find in most environmental laws is that the very same laws that would advance environmental protection would be the exact same laws that allow for discretion on how you can be able to forego those environmental principles. Is there hypocrisy? Some would say there is. I think not, because I think the country is faced with certain socioeconomic realities which we cannot wish away. But the more important thing is that we must not forget that there is this idea of slow violence. It's been propounded by a guy named Rob Nixon. His thesis is that there are some actions and decisions we take today, but whose consequence only manifest probably 10, 15 years ago, not today. So if we go back to the Durban disasters, for example, that we saw, those floodings are not as a result of decisions that were made a year or two ago. They were a long time in the making, probably 10, 15 years ago. The tailings dams, it took probably let's say 1 hour for it to really fall. But that falling started at least 10, 15 years ago because of some decisions that were made or were not made. That is slow violence. When I was in Germany, then I was trying to think, how do we try and mediate this clearly huge predicament that we have? And my thinking led me to this idea called principled environmental pragmatism. And in shaping this idea, when is it acceptable that the state would forego the environmental principle? And in my view, it would be for expediency. So for example, we know the country is struggling right now with load shedding. The point expediency would be for the purposes of dealing with load shedding, although we know that it's better to keep coal in the ground, we would rather dig it up because it's going to help us solve a certain issue, socioeconomic problem. However, my view is that such expediency should never become the norm, because if it becomes the norm, then the environmental principle loses its value and we water it down the more it becomes the norm. And it's part of what I am terming hollowness in a sense. So this neutrality is magnified and is defining in a sense, because then it requires us to look into the specific role of the government in either facilitating or regressing on environmental governance. And the country is peculiar because of three particular reasons, which I think aggravate this issue of non-neutrality. Number one, we are also aware of the issue of state capture, which signifies the erosion of governance through the loss of accountability and professional ethos. So we know governance in general is already under crisis. Secondly, as I've mentioned through the description of the West Coast Rock Lobster case, we have instances where the administrators make at times unreasonable and irrational environmental administrative decisions. And thirdly, which I'm about to get into now, I think we have what I think is a fracture between legal promise and the delivery of that promise. The verdict I reach here is that governance is incongruent. Let's take a look at the picture that you have right here. Incongruent governance is when, for example, you are able to build a river, rather a bridge or a road across the river without due consideration of who stands to suffer. Now, I know we're talking about fish and then it sounds like it's insignificant, but in other instances, we're talking about community. The picture clearly states, a river runs through it, but the fish would argue, but we can't. This is exactly what typifies some of the environmental decisions that are made by those in governance. Thankfully, and for good reason, it creates jobs for you guys, for us, the lawyers, because there's someone that is going to represent the developer and someone is going to represent the fish. Believe you me, there's people that are representing fish out there. Having said that, I think that whole context is a bridge to the bigger problem that we have, which is our laws are, for the most part, ambitious. The term they use in political science would be that they are symbolic laws and policies. These are laws that have aspirational goals that signal certain messages, but are unlikely to be met in practice. Elsewhere, they're described as laws which, despite their often ambitious, officially declared objectives, are ecologically, or rather remain ecologically insensitive. In that sense, let's take a few examples. In a kingdom far, far away, they have a provision that says everyone has the right to an environment that is not harmful to their health or well-being. I don't know how that can be done to ensure that an environment is not harmful to health and well-being. It's no surprise that over 25 years since these provisions came into the fore, we are yet to really see any judgment that really delves and disentangles the provision itself. Another country thought they would go to a utopian space. And if you look at section 69, 1B, they call this country Kenya. It says the state shall work to achieve and maintain a tree cover of at least 10% of the land area of Kenya. Such an ambitious target, I suppose they're trying. But look at 69, 1G. The state shall eliminate processes and activities that are likely to endanger the environment. How do you do that? If you're going to build a house, you're going to endanger the environment. If you're going to do mining, you're going to endanger the environment, but the state shall still have to eliminate those processes. Another state was like, hold my beer, we can do even better. We'll go the rights of nature route. In a country elsewhere where they decided to go Eden route, a return to innocence, as it were, they formulated the rights of nature. And I'll read this for one. Nature has the right to exist, persist, maintain, and regenerate its vital cycles, structure, functions, and its processes in evolution. Now, this is a provision that says everything and nothing at the same time, particularly if you go to section 4.4. It says the minister shall by regulations prescribe the conservation areas for which the rights in subsection 1 apply? How does nature have the right to exist, persist, maintain, and regenerate if it's up to the minister to develop regulations and prescribe the conservation areas for which those rights have to apply? It's a seeming contradiction that is evident in a piece of legislation. But other than the laws themselves, you can also have situations that the particular policies of certain, say, political parties and government ideals are in themselves illusory in a nature. They have abandoned promises. It's very interesting because many a political party in the last few weeks had so many manifestos, and a few weeks from now, we will see if they're worth anything afterwards. But anyway, the point is, when policies contain abandoned promises, what results is patent symbolic reform, the illusion of action and commitment. This all comes to a head now when we get to judicial interpretation, to the judiciary. You've got area laws, you've got symbolic laws, and these laws come before the courts. This is the deadly air case that resolves around the Mpumalanga area. So this area has disproportionately high air quality emissions. And in terms of the applicable legislation, which would be NEMAQA, the National Environmental Management Air Quality Act, the minister is empowered through discretion. It doesn't say the minister may. Sorry, it doesn't say the minister shall. It says the minister may declare an area to be a priority area. Now, the consequence of that is that once that declaration is made, then the minister has to develop a priority area air quality management plan. Because if you declare it, you realize that it needs intervention. And the only way you can do the intervention is to develop a plan. Section 20 then goes ahead and says the minister may publish regulation for the enforcement and implementation of the air quality management plan. What happened is the minister made a Section 18 declaration, developed after the regulations made in terms of Section 19, the plan, but fell short of developing Section 20 regulations. For me, plain reading, it's a chain reaction. You cannot have Section 20 regulations without having had the management plan in terms of Section 19. You cannot have Section 19 without there having been a Section 18 declaration. So failing to heed the process that should follow here would be patent symbolic judgments in a sense, or patent symbolic action on the part of the administrator. Thankfully, the court saw this and interpreted the word may in that context to mean shall. But this very same case is one that I also think it really brought to the fore the problems that are implicit, or explicit rather, when symbolic laws and policies result in what I think would be termed symbolic judgments. The judge in this case made the statement, rather remarkable, I should say, that Section 24 is immediately realizable. The right to an environment not healthy to, not harmful to health and well-being, apparently that is immediately realizable. So scholarship, we know this already, that Section 24 is part civil and political right, but mostly socioeconomic, particularly because when you look at the B section, it speaks about through reasonable legislative and other measures. The moment we delve into aspects of reasonableness, then you cannot speak about immediately recognizable. The means in that instance could not justify the ends, the decision that was reached by the court itself. So you ended up, because of a provision that demands and speaks so much to what should ideally be the case, reaching the courts and then resulting in a court making a decision or a finding that is rather symbolic and it's ineffective. It's rather a brutal fulmen. And I think this is why the case is, as we speak, before the Supreme Court of Appeal. So let's take stock. You've got area provisions. You've got aspirational laws. You've got lofty ideals, which are difficult to render. And on the other hand, you've got socioeconomic realities. The state really is facing difficulties. Our people are really struggling. Then you have progressive realization, the discretion we're talking about, and then me on the sidelines, I'm trying to argue for principled environmental pragmatism. It brings us to the point where we are faced with a pill situation, as was the case for Neo in the Matrix. And when I took my pill, I came to the realization that when there are fractured lines between the environmental promise, which is represented by legal and policy frameworks, and the delivery, which would be the application of those legal and policy frameworks. What we see in South Africa is what I'm terming hollow environmentalism. I'm defining this hollow environmentalism to be the inevitable overall long-term outcome to expect when environmental laws and policies are rendered symbolic through repeated actions and practices that often weaken, water down, or even fail to fulfill the environmental promises. This takes on a way much more amplified and maybe even scary look or outlook when you think about the climate crisis. For one, we've got those who are working on Anthropocene studies. They have already indicated that our actions as human beings are leaving an evident footprint on the planet. And then I've already described slow violence. You've got sensationalists, some who are trying to burn down beautiful historical buildings, standing in the road, protesting so that you can get the attention to their climate issues. And then you've got the capitalocene, which has been described by Arnold Vosloo as an argument wrapped in a word, the idea that capital in itself has grown so much through corporations to a point where they are even staring destruction. Now, whether you believe it or not, I think I've got a midpoint. And the midpoint is that the climate crisis is either before us or it will befall us. Either way, it's either here or it's coming. That is the midpoint I think we can receive. So we go back to the Merovingian and his ideas about action, reaction, cause and effect. Nothing comes without a price. What do we do then? How do we extricate ourselves from this rather difficult position? I should say I'm very proud of these pictures. This is me fishing. I love fishing, by the way. So sunsetting is one of the activities or the governance processes that could be targeted by the state. Sunsetting is the process where activities that are known to present unacceptable dangers to the environment are avoided or retired. We've got two very good examples, coal and oil. So we already know what the impact they have on the environment. But I think it would be unreasonable and unrealistic for someone like me, who's an environmental lawyer, and I've got so many colleagues who would argue for this, to suggest that you must just stop coal mining immediately. I'm on the other side of the fence. I believe that you should rather work with sunsetting. Sunsetting it's governance driven. Because it's governance driven, it has to work with specific timelines. Those timelines have to be accompanied by certain commitments so that we know for a fact we are working towards sunsetting at a certain point, and these are the actions we need to do before we facilitate such sunsetting. But I think an even more acceptable midpoint would be substitution, which I think is a form of due diligence process. When policy decisions are being made, policymakers must prefer pathways that present the least threat to the environment. We are lucky because we have a section 24O, which has this kind of similar provision that has to do with substitution. Again, it has to be governance driven. It has to have a scaling process. So when we say substitution, we're saying, okay, fine, we've got these 4 processes that we need to tackle, or rather maybe initiate in order to address, say, load shedding. We then evaluate them on a scaling process. Which one has the least impact on the environment? The one that has the least is the one that we choose. The one obviously that has the most is the one we put at the background. So this provision particularly, and I should say, it surprises me that it hasn't been used enough in many of the environmental law cases we've seen. It says, where appropriate, any feasible and reasonable alternatives to the activity which is the subject of the application, and any feasible and reasonable modifications or changes to the activity that may minimize harm to the environment must be pursued. I'm hoping to live long enough to a point where we start seeing this provision being fully implemented. Quo vadis advocate. Now, what for the advocate here? It's obviously a detour from the original paper. But I should say, far be it for me to try and presume that I know what an advocate who would be dealing with environmental law would have to deal with, or how they would have to deal with those environmental law cases. In fact, I should say I'm hoping to learn that next year when I join the bar. But the point is, maybe we might go a little bit in history to try and establish certain basics, parameters that I think would be universal for anyone that has to deal with environmental law, or as an advocate or as an attorney, either way. 60 years ago, we didn't even have environmental law. And if you had an environmental issue, it would be solved through nuisance or property laws. Then Rachel Carson came up with a book, The Silent Spring. Because we're not as dumb as we sometimes act as human beings, as you can see in that picture right over here, we then decided to act on Rachel Carson's book. We came with preservation. Environmental preservation is protecting the environment for its own sake from human activity. But then it became evident that, we can preserve, but we also still need to manipulate and exploit the environment for our own benefit. So we then switched, and in addition to preservation, we then also went for conservation. Conservation would be the sustainable use of the environment. So now we're accepting that we still need to exploit the environment, but let's try and do it sustainably. That's how the concept of sustainable development, for example, was birthed. So I think those are the fundamentals. Anyone that would have to deal with an environmental law case cannot help but go back to those. It starts with preservation and conservation. Now, I've got three aspects that I think might be useful in a sense, and I am not pontificating at all here. Those who would be familiar with what we call slasher movies would know, this kind of activity. It's like slashing, getting off an arm, getting off a leg to serve a particular purpose. I think one of the problems we are facing in the country, particularly when it comes to environmental cases, is that we're seeing a lot of severing of legislative provisions to meet a particular end or a particular angle of argument. But this severing loses the substance because it's done without due regard for the context or the purpose of the particular legislation. I'll give you an example. So if you look at NEMA, for example, it has a provision that allows for the state to pursue development activities that put people at the center of concern. That is an argument that could be used for, say, for example, socioeconomic upliftment. But then NEMA also has provisions that say that we should pursue the preventative principle. That's an argument that could be used against those socioeconomic activities. So issue number one, I think lawyers should try and stop severing the legislative provisions and try and read it in context to try and get the bigger picture of what NEMA was trying to do to begin with, and then try and reconcile any existing differences. Secondly, because I'm a skeptical optimist and because I also love the matrix, I believe that there's always going to be two sides of this argument. Assuming that the state is indeed acting with due diligence, assuming that the state has good intentions and that there is no irrationality in the actions themselves, I think any case would be argued either on the basis of necessity and proportionality. Necessity being, for example, arguments that are tailored towards ensuring socioeconomic development is pursued. Our people really need to be uplifted, and it's not going to happen by itself. The government has to pursue certain actions that are going to invade on the environment. And the other side would argue on proportionality. This is a fair balance. You're trying to argue that, okay, fair enough. We understand the need for socioeconomic upliftment, but perhaps that is disproportionate to the argument, rather to the impacts that would be visited on the environment. I believe there's always going to be these two arguments when you go back down to the basics. And related to this would be a totem. If you've watched the movie Inception, you would remember this. This totem represents, it's like a schism as well, either reality or a dream. You don't know exactly where it's going to land. Again, as with necessity or proportionality, assuming that the state is acting with good intentions and good faith, any argument for necessity could win the day if properly argued. An argument for proportionality would do so if properly argued. But I think what we are not seeing enough from lawyers, and I learned this from Germany when I was there last year, is theorizing. I think many lawyers are afraid to theorize. There's too much argumentation, which is straight to the point. There's nothing wrong with that. But if you're going to stretch the meaning of necessity so that it includes certain conditions for our people, for example, then you're going to have to theorize. If you don't theorize, it's just going to be the blanket understanding of it. The same goes for proportionality. Ultimately, it's theorization that is going to help enrich the jurisprudence, that's going to help us make an even better account of ourselves as lawyers. I ended the paper. Now I'm going back from the segue that I'd just taken. I ended the paper that I wrote by these two statements. The symbolic nature of our environmental laws, broadly speaking, is such that the lofty ideals they present cannot always be met by the state. The biggest threat of hollow environmentalism is that it could create the illusion of action, performance, and commitment to sustainability. Unfortunately, courts could be rendered complicit in this illusion when they fail to uncover and granulate the core substance of environmental laws and what exactly such granulated substance demands of states. If I may end with this quote here. Now, this is not the end. It is not even the beginning of the end, but it is perhaps the end of the beginning. With that, I hope I made a good enough first impression for someone that's hoping to join the bar next year. Thank you very much.
Okay. Thank you, Prof. I see we've got claps from Dr. Mabunda. I'm not sure if we have any questions. Do you have any questions on the platform? And if we don't have any questions, I would totally understand. I think the topic was very, very technical to a certain extent. And it opened up our minds and our brains to a certain extent. And then I think I have just maybe one question from my side, Prof. So I would deal with the most of us, actually, not just me, with procurement. And some time ago, I attended a lecture or a conference on procurement. And one of the issues was looking into sustainable development goals in procurement. And I think this issue of hollow pragmatism when it deals with environmental law, one of the things that one must look into, including in, what do you call it, specifications of procurement, is to include some sort of functions that would protect the environment to the extent that it can, so that we don't have an issue of hollow environmentalism, if that's the correct position. Is there a way to bridge the gap between how we deal with it in procurement and environmental law, and how do we bridge the gap between the two? Have you looked into a study of that nature?
Sure. So I actually the year before last year, I supervised a lady who worked on ESG, environmental, social, and governance issues. And I think what you're talking about there in procurement touches a bit on environmental, social, governance issues. The problem is that for the most part, sustainability issues are a requirement as an embellishment. So it's like ticking a box, like in your application, in your documents, do you have mechanisms that ensure that you address sustainable development? Fine, the box is ticked. But then after the fact, there is no enforcement mechanisms to try and ensure that, okay, you promised this to begin with when we gave you the contract. What have you done in terms of meeting those requirements? So I think the answer there is quite simple, that we fail when it comes to enforcement and when it comes to tracing back, but we are all good when it comes to creating the context and the pretext for the inclusion of sustainability. Enforcement is very much more important, but we fail when it comes to that.
Okay. The problem isn't. Then we have a question from our chat, which says, from Hasina, which says, what should a country facing rampant unemployment prioritize? The environment or projects that create employment, like mining and provision of housing?
Well, I wouldn't presume to know exactly how a state would have to deal with this, but what I can tell you is that there are obviously known negatives for the environment if we pursue mining in general. So for example, we could pursue the opening of new mines but then you would have to deal with disasters of those new mines a few years from now. The debate as it stands right now is related to whether renewables will be able to create as much jobs and opportunities as mining would do. The problem is that there's already existing mining and mining towns that have been there for a while. And what do you do with those? And that's why we've got the idea of a just transition, trying to figure out how do we find the balance. As we move, how do we ensure that those who have, for the most part, been reliant on mining are not left behind? So I think it's a matter of, number one, you would have to ensure that those who are already embedded within the mining industry, if you choose to go the sustainability route, which would be renewables, then you have to capacitate them. You capacitate them such that their skills, which were relevant for mining, are not rendered useless by the transition. In that way, you retain those you already have, and you open up more opportunities for those that are to come in. I think there will still remain a space in South Africa for mining. We have the coal, and if we get to a point where we develop new technologies for coal, what we call clean coal, then yes, fair enough. There's no point in us stopping to do that. Australia is doing that, for example. So we might as well continue, but it's contingent upon us finding newer technologies that would allow for cleaner technology.
Okay, I see there's some people who've sent messages in the chat box. We have one from Fumisa that says, thank you, Prof. You are very knowledgeable on the subject matter, much appreciated. I also agree with her. And then we have one from Advocate Bule, which says, thank you for an informative session, Prof. How important is biodiversity? How important is the biodiversity offsetting for environmental compliance? And do you think that the legal provisions in place are sufficient to address the challenges currently in place?
Should I address them one by one, or maybe we can just go with a number of them?
Okay, then we have one from Dr. Mabunda, which says, thank you for the presentation, Prof. I am wondering where we draw the line between ideas to strive for and hollowness. In the same vein as the call for theorize, as the same call to theorize, the land far, far away calls for progressive realization. Is there a point where we can draw the line to say we are not doing enough, but it can't be done overnight? I don't know if you were able to get that. Then we have one from Advocate Nkateko, which says, mine rehabilitation. Is the government doing its best to hold mine companies accountable? So those are the questions we have so far, Prof.
Thank you. Thank you very much. I'll start with the last one, for example, mine rehabilitation. No, the government is not doing enough. And there are many theories that have been propagated for this, that maybe the government is beholden to big mining companies. About 10, 12 years ago, we had these big cases, which we call the Stilfontein saga cases, that had to do with mines in the Harties, Stilfontein there. And they had to do with, for example, the pumping of water to avoid the flooding of other mines that were downstream. And what happened, one of the Stilfontein mines, 3 of the directors, what they did was to resign immediately the moment they knew that they had to do so. And although the department had sent out some directives to ensure that they would comply, that directive was eventually reversed by the Supreme Court of Appeal, apparently because the directive was not clear enough. So on the scientific side of it, I think maybe it's because our departments are not capacitated to be able to make scientific determinations of how exactly compliance should be done. Maybe their compliance documents, particularly the directives, are not clear enough, which is exactly what the Supreme Court of Appeal found. But the other argument is that they do not have to be clear enough for the normal person to understand. They can be scientific enough for someone who is involved in mining to understand exactly what is required of them. So I would say the short answer is that the government is not doing enough. maybe not because they are not as well capacitated, but also maybe because they're beholden by these mining companies. I think more could be done. Secondly, when do we draw the line between the ideal and progressive realization? Ideals to strive for and then hollowness. I mean, they say if you want to fall on top of the trees, then maybe aim for the clouds or aim for the stars. And I understand. Maybe that's why we have these hollow sounding laws, these provisions that are airy-fairy. They have a place in our society. If we can strive for them with a vision of particularly where exactly we need to go, then I think we might be able to fall on the trees. The problem with Section 24, for example, the one that has to do with the right to an environment not harmful to health or well-being, is that it's always going to be difficult to reach that environment in a country where the polarities are such that the rich are richer and the poor are poorer. The only way you are going to try and reach a balance, because the balance is, in my view, will not be reached by the richer coming down. We have to take those that are below and try and bring them up a little bit. And to do so, we have to exploit the natural resources that we have. And then that very process of having to try and raise our people's circumstances would have to be done with activities that are detrimental to the environment. So in that sense, there's already a disjuncture between what we strive for and hollowness in a sense. I don't know if a balance could be found, but I do know that there's no point and there's no way the government is not going to stop exploiting the natural resources. And I, for one, would support the exploitation of the resources we have, maybe with a bit of due diligence. Biodiversity offsetting. I think, so I'm not very much in touch with biodiversity, but I'll speak to offsetting in general. My view is that offsetting in general is one of many mechanisms. So it never works as the main mechanisms for ensuring compliance in a sense. So it has to be part of mechanisms that include administrative settings, include sanctions, include taxes as well. So in a sense, it is industry specific, you could say. But again, it cannot work on its own. It has to be included as part of many enforcement mechanisms. I think that would suffice for now.
Okay. Yes, I think you have answered everybody. I think there was just one question from Dr. Sagwadi that dealt with how do we draw a line between ideals to strive for and the hollowness?
I think I did answer that by my exposition of having to bring our people up, and then I don't think those that are up have to come down.
Yeah. Okay. All right. Thank you. I think we are 100% covered. Now, this is me, I'm taking my powers as the program director. If we looked at the Act, and earlier on you mentioned enforcement, are there any gaps that you find within the Act that perhaps the legislatures should look into with regards to enforcement? Because if the topic is on hollowness, meaning there are gaps, particularly between the ideology of, protecting the environment versus enforcement and compliance on the other hand. And it goes back to the conversation or the question that Sagwadi said or asked perhaps. So with regards to the Act, is there any gaps that you perhaps see on how do we bridge, or there's still some work to be done on the part of the legislature on enforcement and compliance?
There has to be. There is a lot of work that's still to be done. 2 days ago, there was a news article that said Tendele. So Tendele is a mining company that a few years ago was charged under Section 24G of NEMA for starting mining processes without an EIA. They just did so again about 2 days ago, and it was reported. Previously, they were charged 10 million rand, which they paid. So NEMA has, in a sense, some enforcement mechanisms. So it has, for example, fines and the compliance notices, which I mentioned earlier. But these compliance notices and these fines are mostly effective for the small players. So, for example, if you charge a small company 10 million rand for failing to rehabilitate a mine, for example, or for starting a mining activity without the necessary or requisite authorizations, they might not be able to proceed. But if it's a company like Tendele, when they know Section 24G particularly says that if you can have retrospective authorization, you start without the mining license, retrospectively, we might grant you that license, but we charge you a fine. So in a sense, the fining system is functional, but it's only functional insofar as it relates to small players. Big players might be able to get away with murder, as it were. The compliance notices as well. I think in environmental law, NEMA has what we call green scorpions. The green scorpions, I don't think they are capacitated enough. I think they should be able to prosecute. I think if we were to have a court like in Kenya, where they have the environmental court, they actually call it the Land and Environmental Court. It has its own specific enforcement mechanisms, and those mechanisms are embedded within their NEMA kind of law. Their law is called EMA, but they have a particular set of laws, provisions, and procedures that are related to particularly environmental violations, and they can be taken directly to the Land and Environmental Court, which is why in terms of environmental metrics, Kenya is probably leading in Africa at the moment, because they've got that court and that system which was embedded in their 2016 constitution. So yeah, I think we could still do more. We had an environmental court here in South Africa, but it was disbanded for obvious reasons, not least the fact that there were some political players involved. But if we could return to that, maybe the Hermanus Court, which we had prior, or the Magistrate Court that we had, for example, in Kruger National Park, we might have a better track record.
Okay, thank you, Prof. So I guess it's one of those where we need to have a tribunal of some sort that deals with these type of issues. Okay, I see a couple more questions, then we can just close off. One from Advocate Bule, which says, my view is that most corporates put funds aside to pay for the penalties, then proceed to do whatever illegal activities other than the penalties. Do you think there are any other measures that could be put in place? And then there's another comment from Sanan, says, thank you for the informative and engaging session, Prof. I am curious to know to what extent, if any, do you think the hollowness of the laws is attributable to legal strategy? What I mean by that is that risk-adverse litigants would prefer to pursue challenges based on, for example, administrative law, rather than appealing directly to the suspensive environmental principles. I'm thinking of recent Shell litigation as an example for this. If it's a contributory factor, how would you propose that we address the aspect of our legal culture? And Mazibuko says municipal courts capacitated. So we've got 3 more questions. I don't know if you were able to hear me with those 3 questions, but one is, there are companies that are putting money aside. They know that they're going to get away with the illegal activity, and they've made means to pay for this illegal activity. So whether you find them or not, they've budgeted for that. And then with Sanan's question, it's more on a litigation strategy that some of these companies would look into. I don't know if I've captured it correctly. And Mazibuko would then ask if municipal courts are therefore capacitated to therefore deal with it.
So the second question, I did not quite get it. The last one, or municipal courts capacitated. Yes, I think they should be capacitated. They're not. But what we know for a fact is that they don't deal with a lot of environmental issues. But they could be an avenue that could be used. I think the Hermanus Court at some point, it was a magistrate court, but it worked in collaboration with municipal courts. The first question that had to do with companies budgeting for fines. A colleague of mine, Mr. John Rantlo, wrote a whole PhD on Section 24G that has to do with, this whole idea of retrospective authorization. I would think, I don't know if many of you would know I think it's the public procurement bill that just came in. It's got a provision on disbarment. Disbarment would mean for example, if a particular company or a particular bidder is involved in activities that would, if it's corruption or if it's just against any other law, they would be disbarred for a certain period of time from continuing with the bidding process. Countries like Australia, for example, they have similar provisions in their environmental laws. If you, for example, were to disproportionately and particularly if you do so with intention, violate particular environmental laws, like, for example, starting a mining activity without an EIA, the law is clear. We know for a fact the process that has to be followed. I would think provisions that have to do with disbarment would be an avenue through which we can try and make companies desist from this kind of activities. So yeah, I think the one main measure would be disbarment. The second question, maybe if I could read it. Okay, so my view on hollowness of the law, it's not necessarily on the litigant themselves. I think this would be coming from the state. The state would have these laws as open-ended, as idealistic in a sense, for good reason. You can't have laws that are, explicit and to the point. You have to allow a little bit for discretion there. As for legal strategy, I think, and I want to speak particularly about climate litigation, for example. I'll be speaking a month from now on climate litigation, and I'm going against almost every one of my colleagues when it comes to this, because I think there's a lot of overzealousness when it comes to it. And I think we're losing sight of what litigation is actually supposed to do. And we fail to look at the other side. I think there's something to be said about those who are climate naysayers and climate denialists. But because we're so oriented on climate litigation, the state has to do A, B, C, D, companies have to do A, B, C, D. I think it's too one-sided in a sense. So insofar as strategy is concerned, I think as lawyers, as legal practitioners, we are entitled in a sense to craft whatever strategies we can for our clients. But ultimately, I think if we're going to do it from an environmental law perspective, going back to where it all started, that's why I thought the history is important. Are you doing it from a conservation perspective, or are you doing it from a preservation perspective? Is it for necessity, or is it out of proportionality thinking? I think that's where the strategy should rather shift and lie from now going on to the future.
Okay, Prof. I don't see any further questions, and I don't see any other hands from our side. I'm just going to hand over to our colleague, Advocate Buthelezi, who will do our closing and thanking. Thank you.
Thank you.
Can everybody hear me? I'm not sure if I can be heard, but if I can be heard, thank you so much, Prof, for allowing us the opportunity to delve into spheres of law that are quite peculiar, I must say, and are quite detailed and technical. With that being said, if there are no further questions, which I believe at this point there aren't, we would like to just extend a very warm thank you and a sense of gratitude from Pabasa for taking the time off to educate us and give us insight on aspects of environmental governance and different facets of this area of law. I've learned a lot on my end, I must say, particularly when it references that discussion that we had earlier on pertaining to environmental preservation versus conservation. You know, at face value, I wouldn't have thought there was such a difference, but upon listening to what you had to say and what you had to educate us on, I must say that I've learned quite a bit. So I'm not sure. I think my colleague, Advocate Makula, has indicated that there are no further questions. And if that is the case, we would like to say thank you so much in closing for extending your time, your effort in educating us. And thank you for just opening our eyes on this aspect of law. And this is us just saying that thank you, and we are closing the platform. With that being said, thank you very much to everybody also that has taken the time to join us this afternoon on this platform, and you know, in listening to the lecture and having learned together. Thank you guys so much.
Thank you very much.
Thank you.
Thank you, Prof.
Thank you.